Qualys has brought together vulnerability management and patch management, letting security teams discover vulnerabilities and apply patches immediately, all within a single, unified app. Sign up for a free trial of Qualys VMDR, vulnerability management, detection, and response today at securityweekly.com/Qualys. Keeping up with security issues across thousands of web assets without the right approach to web application security is a daunting task. Get ahead with web vulnerability scanning automation from NetSparker, a leader in dynamic and interactive application security testing known for its ease of use and accurate results. Detect a wide range of vulnerabilities in all legacy and modern web applications, address security bugs at scale by automating the confirmation process, automatically prioritize vulnerabilities, and assign actionable tickets to the right developers in their native workflows for rapid remediation. For more information on how to scale application security with ease, visit securityweekly.com/NetSparker. Welcome back, everyone, to Paul's Security Weekly. In our July 14th democast at 11 a.m. Eastern, learn how to protect and reveal your entire attack surface. In our webcast with Psycognito. Then on July 15th, of course, at 11 a.m. Eastern Time, learn how a thoughtful approach to SASE can improve security and enable scalability with the folks from Cisco Umbrella. You can visit securityweekly.com/webcast to register today. If you missed any of our previously recorded webinars, they are available for your viewing pleasure at securityweekly.com/on-demand. Joining us remotely, we've got two of our other hosts with us. Dr. Doug White is here. Welcome, Dr. Doug White.
Hello, I'm here.
Hooray.
I'm getting like all kinds of audio loops in my head, so I can't really tell what's going on, but it's kind of interesting and keeping things wild.
Not different from any other day. Mr. Lee Neely is here with us.
Hey, good to be back from being on the road. Hey, being on the road's a thing. Holy moly.
Right? It's amazing. Joining us in studio from Roger Williams University is Thomas Lonardo, Associate Professor at the School of Justice Studies. Thomas has 25 years experience as an attorney and is a member of the Massachusetts, Rhode Island, and Federal Bar Associations, and joins us today to discuss the CFAA and the recent Von Buren versus the U.S. case. Tom, welcome to the show.
Thank you. Thank you very much.
Tom, is that okay?
Please do. Nobody calls me Thomas except my late mother, so that's okay.
And only when you were in trouble.
Exactly. Yeah. I have no middle name, so it really didn't matter.
Well, you're not in trouble with us yet.
Lighten up, Thomas.
Whoa, hey now.
The CFAA, I have this trivia question that I asked at a lot of different conferences, and of course, as Larry was describing before the segment, we're not attorneys, we don't practice law, so we try not to give our audience the impression that we're giving legal advice or have any deep knowledge of how a lot of these things work and how laws are interpreted specifically.
So I fit right in. So that's good.
This is tricky business. Yeah. But my trivia question is for the CFAA, which I believe was enacted into law 86, 87?
Originally it was 84, part of a Computer Crime Act, and then they codified it in 86 as an official CFAA.
Who was the first person to be tried under the Computer Fraud and Abuse Act?
I have no idea.
It was actually Robert Tappan Morris. It was very famous in our field for creating the Morris worm. His dad worked for NSA at the time. He was at Cornell University at the time, and I believe is still a professor today at MIT.
Yeah. Okay. Yeah. Well, I'll have to remember that next time I'm here.
It's a fascinating story, and so I had kind of researched that particular case, and then I was reading one of the books I read recently that we talked about on the show. It might have been Cyberpunk. I think it was Cyberpunk. And they chronicle 3 different cases of computer security history. One is Kevin Mitnick. Actually, computer crime history, right? Kevin Mitnick, Pengo, and the folks that were in Germany at the time that tied into the Clifford Stahl case of espionage. And the last one was Robert Tappan Morris. And they go into the details that they could gather from the actual trial. And one of my assessments was it sounded like the attorney representing Robert T. Morris, I don't know that he wasn't very good, but wasn't well versed in computer crime law. But then again, who was that was like 1987, I think, when that case went to trial, right?
Yeah, that gets missed in a lot of these cases. Is you read these appellate decisions and the U.S. Supreme Court decisions, and you don't get that insider baseball type of situation that's going on. Like, what did the witness look like on the stand when they testified? How credible were they?
Yep.
It gets lost in the judge's decisions oftentimes because they're trying to be very brief and very cold in the facts as they present them. So, yeah, a lot of things get lost in the back history of a lot of these cases.
Yeah. Absolutely.
So,
are there other like, have you looked at other famous or not famous cases that were tried under the Computer Fraud and Abuse Act?
I looked at the Keys case, and what was the other one? In fact, the Nossel decision. But this one, believe it or not, is the first one in 35 years to make it to the U.S. Supreme Court.
Interesting.
And there's a reason for that. I don't think it's because it's a greatly written statute. It's not because it's ironclad, far from it. But I think not knowing the process in the judicial system, only less than 4% of the cases actually go to trial. Most of them are pled out, dismissed.
Did or tried under, we say Computer Fraud and Abuse Act. It is Title 18?
18 U.S.C. 1030.
Yep.
That's the act. But on the civil side and on the criminal side, out of all the cases that are brought and prosecuted, less than 4% actually go to trial. So you take that percentage of cases, and then you say, okay, how many people got convicted, and how many people got convicted had the money to appeal it?
Right.
All right. So it's to say, well, it took 35 years for this to get to the U.S. Supreme Court, I'm not surprised, because in 2014 was the first case that the U.S. Supreme Court says that the police need a search warrant to search cell phones in the Riley v. California case. And so it does take a long time to wind their way through the court system and the appellate process, because not everybody appeals. Some people are saying, I'll take the 6 months, I'll take the 18 months, and they live with their sentence.
Right.
I think this case was different because he was a police officer. And again, you don't get the backstory.
Let's recap the case.
Okay.
Because it's kind of interesting, and I have some specific questions once we recap it, but I think we should recap it, for our audience, certainly.
Okay. Sergeant Van Buren was in the Cummings County, I believe, Georgia police force. And he was running into some financial problems, apparently. And he was socializing with this guy, Albo, I believe his name was. And he was told, that is, Van Buren, to stay away from this guy because he was bad news. As my late mother would say, he wasn't right. He was into prostitutes, drugs, and ultimately, by the way, he ended up going to Italy, and he never testified at the trial.
Interesting.
So anyway, he recorded the conversations with Van Buren, and the FBI was involved. And he ultimately gave Van Buren $6,000. And he asked Van Buren, as part of the sting, to look up a license plate number of this fictitious stripper, apparently, because he wanted to make sure she, quote, wasn't an undercover cop, because I guess that was his business. And he did so, and he was all on tape. He was prosecuted, and he was convicted for violating Section 1030A2, which is obtaining information from a protected computer for monetary gain. That's the kind of the Reader's Digest version of what he was convicted of.
So there is in the law the fact that he accepted money for...
That made it a felony. That got him 18 months, okay? Otherwise, it would just be a misdemeanor, which would be less than a year and a fine.
Because that was the interesting thing for me. I'm like, to me, the real crime was he accepted money to access something that he may have legitimately had access to for his job. But to me, the criminal act was accepting the money. But it's deeper than that.
Well,
you have to share it and accept money.
Well, the real issue is under the statute, $5,000 is the threshold for a felony.
Oh, Interesting.
Okay, so he accepted the $6,000. The FBI made sure it was over $5,000
Of
when
course
they got
they
him.
did. Of course they did.
Yeah, so ultimately he appealed it, and like I said, the guy. The other question was, why wasn't he prosecuted under the state bribery statute?
Yeah, that was one of the.
Well,
I didn't know about the state bribery statute, but I'm like, why wasn't he tried with something different that was more?
Well,
about
I think because once the FBI got involved, they took over the case. They took over jurisdiction because they saw what seemed to be a slam dunk. And at the trial level and at the appellate level, it was a slam dunk.
Interesting.
Based on the interpretation of the statute. So now we're in the 11th Circuit Court of Appeals. The attorney for Van Buren makes the argument that, hey, the statute as it reads, and I've got the terminology relative to, well, let's just get some terminology out of the way. Without authorization, basically is a hacker. It's somebody who does have no business being in a system, all right? Without or an excessive authorization is typically an insider who has the ability to be in the system but is not allowed to go into various areas. All right, they don't have the authority or the authorization or the permissions to do that. Okay, he was prosecuted under in excessive authorization or exceeding authorization, not as an outsider, because he worked for the police department.
Right.
And when he went onto the system, the Bureau system, to look up the license plate, he was on the system. And the 11th Circuit said, well, an excessive authorization means that you have access to the system and you used it for an illegal or an improper purpose. Okay? And that's how the 11th Circuit looked at these cases. Now, I'm not sure if you understand the circuit system in the United States. I don't want to go through again, inside baseball. But, for example, a decision in the 11th Circuit is not binding in the 9th Circuit. The First Circuit decision...
Well, I guess describe the circuits.
The circuits are... The circuit courts of appeal are territorial. There are certain states that are within, say, the First Circuit, Rhode Island, Massachusetts, Maine, Puerto Rico.
So they're like region.
They're regional.
Yeah, okay.
So in the 9th Circuit is the West Coast. Okay. And the 11th Circuit is Florida, Georgia, the southeastern states. Okay. So within the federal appellate system, you have these circuits all over. There are 13 circuits, and they all have their own jurisdiction. Jurisdictions of power to hear cases and to decide them. Okay. Well, if you have a case that is decided in, say, Massachusetts in the First District Court as a defendant and you lose, you can bring that to the appellate court in the First Circuit. You can't go to the 11th Circuit.
Right,
and whatever the First Circuit Court of Appeal decides is only binding in those states within that First Circuit.
Oh, interesting.
So
So these are federal.
Federal. This is the federal system, okay? So when does the United States Supreme Court hear a case? They hear a case on important matters, number one, and typically when there is diversity in decisions among the circuits, when there's a disparate decision. So the 9th Circuit's deciding it one way, which was the Coney Barrett decision, how she wrote it. And the 11th Circuit is a much more broader interpretation of in excessive authorization, which is a wider net for the prosecution. Okay.
Does the Supreme Court decide if they're going to hear the case?
They decide. They only hear. I think it's like 200 cases a year, something like that. And they will. It's called granting writ of certiorari. They won't hear every case. There are thousands of cases in the file with the U.S. Supreme Court.
Right.
And what will happen is they'll say, okay, is this an important matter as it relates to the district decisions and to the law itself? And they'll interpret federal law in the Constitution. That's their jurisdiction. Okay. So primarily, so they don't have to hear every case. In fact, they hear very few cases during the term of the Supreme Court. So for a case to actually, and we talked about, why 35 years, for a case to actually get up to the Supreme Court, it has to go through a very circuitous route in order to get there. I mean, there are a lot of things that you
mentioned earlier, like the person has to have enough financial means to be able to appeal
financial means,
right?
And it has to be an error of the court.
Yeah.
You just can't. I don't like the jury's decision. I'm going to appeal it. You can't do that. The appellate court will only hear a case where The judge at the lower court made an error of law, either deciding a legal issue relative to the interpretation of a statute, evidentiary issue, whatever the legal issue that is decided by that judge, you have to assert as the appellant that there was a legal error. And that's the only way you get standing to appeal.
Yeah, yeah. That makes perfect sense.
Well, I wish my students said that.
Yeah.
It would have been really nice.
Otherwise,
their eyes glaze over after I get to the district court, which is the main trial court.
But otherwise, everyone's just going to keep appealing.
Everybody, exactly. It was just a free for all.
Yeah, the irony, I think, is that your students are there to learn because they likely want to become legal professionals and lawyers?
No. I teach in the business school, and I teach in the School of Justice Studies. In fact, Dr. White is the guy who hired me to in 2008 to teach computer forensic law.
All right.
And outstanding. Good job.
Yeah. So that
but it also makes sense in the
tangentially how we got
the
here.
balance,
Okay.
right?
Right.
That there are in the legal system checks and balances to go if there was a mistake or an error in the process,
right,
that we as citizens have a path.
You
to
do.
that. Yeah, it makes
exactly
perfect sense. And pretty amazing that this case made it all the way to the U.S. Supreme Court.
Well, the cheerleader case just came down from the U.S. Supreme Court. So what does that tell you? I mean, it was just like...
Is that the cheerleader where there was fraud?
No, that was a cheerleader that was a First Amendment case where she didn't make the cheerleading squad as a freshman, and she just ranted profanities online, and they... I guess suspended her or whatever they did.
It was, and I only saw it on the news this morning. So she was junior varsity. She tried out for varsity. She didn't make varsity.
Right.
And she went on
TikTok,
Snapchat, and posted profanity like f the sports team, f the school, f cheerleading, and the middle finger because she didn't make varsity, and the school suspended her and removed her from cheerleading, both varsity and or junior varsity, and told her, nope, you're going to have that kind of attitude. We don't want you here.
No, the irony is if she had graduated and that case was still in the court system, they wouldn't have heard the case because it had been moot.
Right.
It doesn't matter.
Yeah.
So, anyway.
So back to Van Buren. Now he's in the 11th Circuit.
Well, yeah, he's the 11th Circuit. He hit the jackpot with the 11th Circuit where they upheld the lower court decision of the district court, and he's serving 18 months. So he appeals it to the U.S. Supreme Court. They grant a writ of certiorari. He gets heard, and the judge who wrote the case is the newest judge, Amy Coney Barrett. She wrote and actually when I read the decision, it looked like, I mean, she's brilliant, but it looked like a law student wrote it because it was very, it had a methodology to it. In the laws, it's basically they use IRAC, issue, rule, analysis, conclusion, and she followed that paradigm to the T, right?
Yeah.
Interesting.
So what you're saying it was legible.
It was legible. Although I will say she really got caught up in linguistic gymnastics in justifying. When I see a judge or going through one word and the word is so, like President Clinton is what the definition of the word is. Well, with them with her and the majority was the word so.
How so?
That's not the word Clinton was concerned about.
No, that's not what he was.
No, that is definitely not what.
Okay, so let me just read the definition real quick. This is why, because I don't memorize this stuff. In fact, I tell my students I don't really care if you know the name of cases as long as you know the law.
Yeah.
Because at the end of the day, nobody gives a crap. All right, you just need to know what the principles of the law are and how they apply.
Man, where were you as a professor when I was at Roger Williams?
And I always assign very short cases because I don't want to read long cases. This case was 37 pages long, including the dissent. And the dissent was actually more interesting than the actual decision. But as far as what the clause in the statute that was in question, which gave rise to the word so. The term exceeds authorized access means to access a computer with authorization and to use such access to obtain or alter information in the computer that the accessor is not entitled so to obtain or alter. She really looked at that word so, and she basically turned the whole case on that word so pretty much. I mean, it was really complicated because it was like she was really going through these grammatical issues of modifiers. And I said, at the end of the day, what are you trying to say? And what she actually ended up saying is this: not much. She says, when you go into a computer that you are authorized to go into,
which Van Buren was as part of his job,
which part of his job, and you and in an area that you're authorized to go into, and you obtain information,
which he was, because as a police officer, you would go access someone's license plate information. Correct.
Right.
Wasn't she essentially trying to establish mens rea?
Well, the mens rea was already established by the intent.
I only know that term because I watched Legally Blonde, by the way.
Oh, okay, yeah. So,
can you describe that term?
Mens rea is the requisite state of mind. You need two things to commit a crime. You need the requisite state of mind, which is the mens rea, intentionally, knowingly, willfully. You have to actually intend to do something.
Right.
Okay. In this case, it was an intent to access a protected computer. The actus reus is the actual accessing the protected computer.
Right.
And without those two, you don't have a crime. That's why not guilty by reason of insanity lacks the mens rea. Therefore, you can't convict a person, or if they're found not guilty by reason of insanity, they don't go to jail. They don't go home, but they don't go to jail. Right. They go.
But my question was serious. I mean, it sounds like "so" was the action verb. It was trying to. She was. I haven't read it. You're reading it, but it sounds like she was trying to get to motive and intent.
Well, actually, to flip that on the side, what she was really ultimately saying is motive is irrelevant. Using it for an unlawful purpose is irrelevant to the statute. What is relevant to the statute is that you went into an area of the computer that you were not allowed to go into. That is what exceeded authorized access means. So she really was not saying motive, because his motive was actually to do something illegal, obviously.
Right.
But his motive, insofar as this, in the purpose for him doing it, actually played against the prosecution in this case, against the government, because they're the ones that are saying, well, it's because of the unlawful purpose, why he did it. He didn't have the right to do what he did. He had the right to go in there, but as soon as he did something unlawful, contrary to the policy of the police department, he lost his authorization. He lost his permission. And she said, no, that's not it. And she used what they call a gate up or gate down analysis. If the gate is up, if the sign says employees only, and I go in there, well, the gate was down. I should not have gone in there. Okay? If the door's wide open and there's no sign and I walk in and I find something I shouldn't and I'm not sure why I should be in there, there's nothing prohibiting me from being in there. There's no notice. Then I basically am allowed to be there. So what she's saying is, if you're allowed to be somewhere, it doesn't matter what you do once you get in there. That's not the violation. The violation has to stem from getting in there and having the authority to get into the file, to get into the area of the computer that you're not allowed to be.
So she really clarified the CFAA in that respect.
To a point.
To a point.
And here's where she fell short. She never said what she means when the gate's down.
Yeah.
She never said, well, the gate down means a password protected file. The gate down means that you have a banner that goes across. She never said what that gate down meant, and that didn't really close the loop.
Or you have to log into the system with a username and password. Maybe that's the gate.
That could be the gate, but she never really said what that gate should be. Okay, it kind of leaves it open.
Isn't there an issue there of scope? I mean, so like I was doing this case one time, and they told us that we could only look in this one directory, and that was called C:finance. And I actually asked the legal person. I said, so what if I see a directory that says C:'child pornography? Can I look in that folder? And he said no.
What if there's a
And
soft
so
link in that
that was
directory
my
to
scope.
another directory?
Or
If someone's standing there and saying you cannot go into that directory, you cannot go into that file, unless you're law enforcement and you're doing a search, I don't know, you're doing a search pursuant to a warrant, and you're looking for evidence of drug running, all right, or weapons dealing, and you're going through a search of the computer. I know this is getting to the Fourth Amendment, and you're going into the computer and you see a file that says child pornography. You can
That's
open
plain
that
sight.
file.
As law enforcement.
Yeah, that's plain sight. But what if you don't see it and you go looking for it? So you go open the directory and there's 8,000 files in the directory, and you look at the one that says C:finance, and you decide you're going to start scrolling around and opening other directories and all that kind of stuff. That's what they were telling us we couldn't do. They said
No.
you can only look in this one directory.
No, because your permissions are directed to this particular file and directory. Once you go beyond that, now is this the company that hired you to look at their own computers, or was this a third party?
It was a court-ordered search of a. It was a civil case, but it was a court-ordered search of a.
Yeah, usually
former employee.
those subpoenas and searches are very, very rigid and very narrow in their scope.
Well, that's why I was asking, though, because I was like, our policy is that if we see evidence of illegal activity, we want to get the police involved, because that's what the CCE says. And, it was like, so what if I open this guy's machine and we see a folder that says child pornography or, whatever, child trafficking? Can I look? And the lawyer said, no, you should.
Well, if you're doing it pursuant to your normal and authorized search, and you come across it, you're not law enforcement. The Fourth Amendment only applies to the government and those acting as agents for the government. And if the government says you run a computer repair shop, do me a favor. Johnny Bag of Donuts is bringing a computer. I want you to look through that computer, see if there's anything nefarious in there for me. Well, now that computer repairman is no longer a computer repairman. He's an agent of law enforcement, and therefore anything search that he does is a violation of the Fourth Amendment.
But if he does it without law enforcement's directive,
and he drops a dime.
Yep.
And then
it has to happen in that order.
Then they get a search warrant and based on the informant's information. Mm-hmm. That's how it usually works.
Going back to the Van Buren case.
Okay, I'm sorry.
all good.
Is the case now dismissed? Is that what was the end
It's
result?
done. It's been dismissed. He's out free. It's been vacated.
In your opinion, Tom, did he still commit a crime? And if so, what would you see as the charge be? Could they have charged him with something different that would have had a different result?
Not at the federal level. Not based on this decision. They probably should have charged him with bribery.
Which is that a federal?
No, it's a state offense.
Okay. That was my question. You answered my question.
The computer was an instrumentality of the bribery. It wasn't part of the CFAA breach, so to speak.
Right.
So whether he took a hard copy file from the file cabinet and did something for money and provided some information, maybe. In fact, I was watching a Law and Order episode, one of my favorite shows, the old one with Jack McCoy, where this woman was an undercover police officer, and she was outed by this politician, and he tricked somebody in human resources to give him the information. Well, if they didn't trick him, the human resources person was paid $5,000 to give him that information. Well, that HR person would have been taking a bribe. Right? And if that person died, he would have been a conspirator in a murder. Okay? So at the state level, that's probably where the prosecution landed. The bottom line,
he's not going to be charged again because you can't be tried for the same crime.
No. But he can't be tried for bribery.
Oh, because that's a different crime.
That's a state crime, a state jurisdiction.
And a different charge.
And a different charge altogether. Right.
And so would he likely serve jail time?
No, what'll happen
based on history?
Here's what happens. This is what happens in Rhode Island typically. And Doug knows this.
A lot of bribery cases in Rhode Island? Is
Wait, Doug knows this?
Well, because he's been living here long enough.
Okay, good.
See the car he drives?
Let me put my phone number up on the screen just in case anybody wants to send some cash over.
Basically, he's a police officer. He lost his pension. He's been fired. He probably couldn't get a job being a police officer, an attendant at a washroom. Okay. So his career's done. His reputation's down the tubes. The government is not going to spend money prosecuting somebody that it's going to be difficult to prove, because now you've got this case, right?
Yeah,
So you take
yeah.
a bribery case, and even if the jury is not aware of what happened, the fact that he got dismissed and it got overturned, it's going to color the jury's perspective on this
Right,
case at the state level.
His life's already ruined. How much more do they need to ruin it?
Pretty much. I mean, the guy sounds like he was in the toilet before he did this. I mean, it's just like, really?
Yeah.
He just is not going in the right direction. So that's what happened in the Van Buren case. Now, what's going to happen in the future? There'll probably be more cases. I don't think this clarifies a lot. I think from a practitioner standpoint, what you just talked about relative to the gates down analysis, password protections, and even she said that even if terms of service are not enough, if there are terms of service, because let's face it, if you violate the terms of service of Facebook, technically before this, you violated the CFAA.
Right. That was significant in this room.
And from that is huge. That is a huge issue.
Because there was a case with, was it Weave? Andrew... what's his name? Auernheimer.
Oh, yeah, the Auernheimer.
The Auernheimer case would that have a different outcome now based on this new ruling?
It would. And in fact, if the case is already settled, by the way, the Supreme Court's not going to hear the case. They'll say it's a matter of settled law. We're not going to hear it unless it has a certain nuance to the in the appellate court that makes it substantially different than how this was decided. If it's basically the same facts, they're not going to. What they'll do?
Auernheimer already served his time and I think got out, right? I think.
Yes.
Yeah.
And then there was the Keys case. Was it the reporter? I believe where he.
I'm not familiar with the Keys case.
Yeah, I think he was a reporter who. They never were clear whether he was fired or he left, and he basically was hanging out with a bunch of shady hackers online, and he basically was. It was the Los Angeles Tribune, I think, that ultimately got hacked, and he admitted to it, and he said it was just a joke, and it was only up for 40 minutes. He changed the headline to one of the, and he actually was prosecuted and served time. And he actually, well, it was, they called damage under the terms of the CFAA is a very broad term.
Yes.
If you damage a computer, it could be almost anything, not just monetary damages. If your employees, for whatever reason, have to react to it, that employee time goes to the $5,000. And if you damage a computer, that adds up to a lot of money.
Or if you steal information, the defendant needs to place a value on that information?
No, the plaintiff has to put the
plaintiff. I'm sorry.
Yeah,
the plaintiff puts a value.
If it's a civil case, the plaintiff always has the burden of proof in a civil case.
Yep.
And the state always has the burden of proof in a criminal case.
Because there was an early case with not telephone hacking, but it was a computer hacking case, and they stole the 911 documentation from, I believe it was the phone company. And the phone company put this exorbitant
$969,000 as a fee for response. I can't think of the name of the case, but yeah,
you're familiar. So you're familiar with that case?
Yeah. They just ran up the numbers. I mean,
right.
they talk about piling on.
The defense seemed to disprove that and go no, someone can pay $17 and you can get mailed a copy of this information.
Right. But then there was attorney fees. In fact, there was an attorney who actually, they found an email from an attorney who said, we got to keep running up the numbers to make sure he serves some time.
Interesting.
Oof.
Yeah, that wasn't good. But he still got convicted.
I think he did get convicted.
He got convicted.
Yeah.
And he served less than 2 years, I think. It wasn't a long sentence. But the judicial system is a game of deals, and say, wow, they overcharge. That's what they do. I mean, if I'm trying somebody for first-degree murder, and it's a death penalty statute, which is the federal law, there are death penalty statutes, I'm going to threaten the death penalty. I'm going to overcharge. I'm going to overcharge first-degree murder, and I'll plead down to second-degree murder with 25 years to life. So that happens all the time in the judicial system, as far as how the games are played, so to speak. Yeah.
So in the case of CFAA, we did, I think, clarify one point, that moving forward, that terms of service don't define or can't be used to determine if it's a federal crime under this statute.
Well, yeah, the terms of service cannot. cannot say, as far as exceeding authorized access, that doesn't protect the company, and
Right.
it doesn't allow for a prosecution.
Larry, your question surrounding this was also, what if I share my Netflix password with someone?
Yeah. So
Does that just violate their terms of service?
That's
in
a
this?
terms of service violation.
Yeah.
Yeah, absolutely. Versus stealing his password. I mean, I used
You're
to.
supposed to say asking for a friend, Paul.
Yeah.
Well, no, Larry. No,
Yeah. No, we were.
I wasn't implying that Larry was we were sharing passwords. Larry or I were
Yep.
sharing passwords, but talking about that as a hypothetical situation.
Well, you know, and people share their account on Netflix all the time,
Yeah.
and it's not like Netflix doesn't know about it. In fact, in some cases, they encourage it.
Yep.
Many cases.
Yeah,
I'm
and
a
that was
bank teller,
and that was.
and I'm
Oh, sorry,
sorry,
Jeff.
Larry.
That was sort of where we're postulating on that. We're like, hey, we really don't know what the hell we're talking about. It was along the lines of like, hey, I have a Netflix account. I share my password with Paul. He has permission to be in that system because he has a username and password. It just happens to be mine, and I gave it to him. He then goes and watches a movie that he has access to, but he really shouldn't. So it's kind of like stealing.
He really doesn't have access.
I mean, he does.
He doesn't
but
have.
It's not. But it's in violation of the terms
It's
of
not
service.
authorized.
It depends how you define
Yeah.
so.
And-
So
yeah,
I'm going
not
to
really.
jail.
To watch the movie.
And then,
so-
then
Yeah.
you got to get it over $5,000. So when Paul decides to record the movie and distribute it on his own private DVD label,
Right,
so
yeah, that's
everybody
not
can
good.
Find. Now
That's a
I
whole
can
bunch
say,
of
well,
other
each one
charges.
of those
Piracy,
showings
yeah.
is worth $5, and I'm going to multiply that times 50, and on and on and on.
Yeah. Then you
Yeah,
have
that reminds me, Doug, of the one legal question I've always wanted to ask. Am I allowed to rip that tag off the bottom of the chair that says "Do not remove this tag"?
I'd be serving serious time if that were the case. I just,
Hey, Jeff, if you actually read the label, it says may be removed by the end consumer.
End consumer, yeah.
Yes, it does.
But that depends how you define B.
So
No, we're coming back.
So right.
So-
Here we go around
So
Tom,
But my other question
Go
was,
ahead,
sorry, Paul, if I can throw it in real
Yeah,
quick.
go ahead.
I'm a bank teller. I'm allowed to walk into the vault, and I walk out with a few extra packs of cash. I'm committing a crime, aren't I? But
you're
I'm
committing
authorized.
embezzlement. That's called a bailment. And that's embezzlement. Yeah, that would be embezzlement. It's not a computer crime, but it is a crime because
So
you
what
took
I'm
you
hearing
took
is
you took the money that you had. You were entitled to be there. You were entitled to handle the cash. You weren't entitled to convert it to your own property, and that's embezzlement.
So what I'm hearing you say is computer crime law still has some catching up to do.
But
Wow,
no,
yeah, and
but that
using the courts are fond to using. That's not even want to using like real life analogies. Like in the Fourth Amendment, they'll use a file cabinet for a computer, and they'll use the drawers of the file cabinet as different files within the computer, and did the same thing with this. In fact, the dissent relies on property law and trespass as a common law trespass to support the case that once you're in somebody's property and you're using it at adverse to the owner's either request or intent, you've trespassed. And so if you go out to my property and I ask you to leave, it's trespass.
Right. Now, my next question is interesting that Jeff gave the bank example because it's clearly embezzlement if the employee goes into the bank vault and steals money, right? It's also what if someone goes to the bank and withdraws money? Now, in both cases, the bank teller and the bank customer, if they leave that money behind the dumpster, behind the bank, and then I just happen to walk up and see that money there and I take it, is there a difference if it was a legitimate person who withdrew it?
Is this a finders, keepers, losers, weepers defense?
But now I want to put this in terms of computers and computer security. If I'm on an underground forum somewhere,
right,
and I'm looking around and I see a file that contains a whole bunch of credit card numbers or a whole bunch of usernames and passwords, and I download that file, am I committing a crime, or does it depend on what I
no,
do with that?
it depends what you do with it. If you well, there's another trafficking in passwords and IDs, so that's another 1030 violation.
Interesting. Okay.
So if you just hold them and do nothing with them, you've done nothing. But if you start selling them and just in
what if I share them? What if I put them somewhere a few of my friends can gain access
well,
to
then
them?
you're basically that is something of value that you are converting those password and those files to. In other words, if they're credit card numbers and you're giving them to your friends to go into Home Depot.
But what about usernames I mean, there are actually legitimate companies that will uncover.
Well, that would be you'd be
passwords.
trafficking in passwords, and that would be a CFAA violation if trafficking is actually giving them away.
Yeah. So like, how does Have I Been Pwned? How do they operate? Because they have a whole database of the passwords that were leaked in data breaches already. Like someone broke in, stole a bunch of usernames and passwords. Then they committed a crime by sharing them with the world, and then Troy Hunt puts them on his website.
But he doesn't give them away. He only takes your password, looks it up against the database, and says, "Yeah,
okay."
So he
keeps your password and adds it to the list.
yeah.
It's like
it's
chain
a
letter.
logical outcome. So it's just a true or false, right? I mean, he's not actually giving you the passwords.
I gotcha.
Yeah.
But silly question, but a serious question too. The old adage that possession is 9/10 of the law. Does that not apply in this case?
Possession is 9/10 of the law. So
you were saying if you steal the data, computer data, that's a crime.
Right.
If you use that data to, let's say credit card data to commit fraud,
right,
that's a crime. But just being in possession of the data,
that's not a crime.
Not a crime.
That's not a crime. No.
So possession is not 9/10.
Technically, nobody's really harmed. But if you're just sitting there with a bunch of passwords and not doing anything with them, you're not giving them away, you're not distributing them, you're not selling them, there is no harm at that point. Okay, because
so if your intent is to do good with them and tell the people whose passwords were leaked,
like your Robin Hood, and
you're Robin Hood. Well, that happens in our field, right?
Yeah.
I mean, there's services that do that. I mean, we tested services that in scanning the internet for what would be our data, right? So we gave them the name of our company, and there's companies that will go search the internet and find anything related to you. In some cases, they found valid credentials, whether they're valid or not is a different discussion, but they found credentials.
It was open source. Anybody could have found them?
No, they open source. Anyone could have found them, right? They're out there, and they report it back to me and say, hey, I found some of your passwords, credentials. You should probably have those users change their passwords. That's
I mean,
cool, right?
If it's open to the public, I mean, if you find something, and it's when you trespass, they use that trespass word again, to steal something. And when I say steal something, it's just not physically, obviously. If you view something, that is obtaining property under the laws, under the Computer Fraud and Abuse Act.
Right. So it's more the person that stole those credentials in the first place. They're the criminal, not the people that are handling the data afterwards, unless I'm selling it.
Unless you're selling it, or if someone gives it to you, you're a co-conspirator. Right? And someone says,
or what you have is inherently illegal.
Hey, receiving stolen property.
Well, no, not stolen. I mean, so there's a difference between a password, which is not
password's different, right,
and say a child pornography photograph that you say I just found this laying on the street. If you have that, it falls under the same thing as I found this brick of cocaine out behind the dumpster. That's why it's in the trunk of my car. You still get arrested
under the wheel well.
A brick of cocaine.
Yeah.
Even if you say I didn't buy it and I didn't make it, I just found it sitting on the street, but I'm carrying it around in my car.
Well, how about this more of a scenario where we got a disgruntled employee and they take a bunch of the stuff their employee is working on and they post it on WikiLeaks? Have they broken?
Well, they had access already. They had access to the system. They had approved. Were authorized to do that. That's where this comes down.
Yeah.
I mean, if you're authorized, and this was the case. Oh, damn! Where the insider provided information to the person who left the company, and that person was going to use it to start their own business. Okay, well, they wouldn't run afoul of the CFAA because they were authorized to access that information. Now, it is a theft.
Right.
It is property. Information is property, and it doesn't, even if it's computer information, it's property if it has a value to somebody. All right. So if whether it's trade secrets, whether it's a code, whether it's something that has a value to someone, a customer list, it's property and it's theft.
I see why that differs from credentials, because credentials aren't necessarily property in that sense. They're more like the key.
Yeah,
like it's like I lost my keys and someone found my keys.
Use the analogy of a car.
Yeah.
I mean, you give somebody his Tom's car to his Corvette. Here, here's the keys. Go steal it. I mean, it still has a property value. I mean, does a password have a value to you? If you had to go into your Bank of America account and someone had your password that they shouldn't have, is that something that has value to you?
I mean, what's in my account has a value.
Well, not in my account, but maybe yours.
It's Doug's account.
There's butterflies floating around. There's nothing in my account.
Is that fiduciary harm?
Oh, here we go. Fiduciary.
Loves the term.
Oh, fiduciary. I was waiting for fiduciary harm. I don't even know what that means.
Oh my goodness!
I was so impressed when he used that term the first time. I was like, wow, Doug, like you really know a lot about the law. Like I'm impressed right now.
Big words, Doug.
Yeah.
Yeah.
That's harmed by a fiduciary, someone who has responsibility to take care of your affairs, and they breach it, and you suffer harm.
But does Doug have a pecuniary interest in this?
Oh, pecuniary is always a good word.
Tell the truth, Paul. You were mildly impressed when I said mens rea too.
Mens
I
rea.
was.
I thought it was a fish.
Yeah, I thought it was like a cream you needed
I have
for
to go
something,
back
Jeff.
and watch what was the movie you said it was from?
Legally Blonde.
Legally
I
Blonde,
watched
mens
it.
rea,
It's a good movie.
actus reus, all that Latin. That's all Latin I know besides pig Latin, to be honest with you. That's it. It doesn't get.
I thought all attorneys had to know Latin. Wasn't that
Oh,
required?
yeah, I used to throw some res ipsa loquitur in there and respondeat superior, and it doesn't mean anything.
Gratia
as far as
saga
I'm
Deus
concerned.
Veneris.
Yeah.
Gaudeamus
E
sigatur.
pluribus unum. I mean, I don't know. That's all I know. So.
Well, that's awesome.
Yeah, it's
thank
kind-
you for
it's-
coming out
no,
and
it's
digging
my
digging
pleasure.
into that. I like.
to be honest, what's more interesting to me anyway is that I'm a process person. So the process to me is, besides the decision,
Yeah,
how it got there,
Right.
and the backstories, and how these things ultimately get appealed, and why they get appealed, because you don't know what happened at the trial. I
Right.
mean, nobody knew that the key witness went to Italy, and and the defendant never
Isn't that the
testified.
plot of The Godfather?
Yeah, right. Yeah, Apollonia. Don't start up that car. It's a Pinto. Anyway, so that's what's so it does help a lot of issues relative to cybersecurity. Certainly, security research, it does help a lot in that regard. But if you're working for somebody and they're asking you to go through their system, you clearly have authorization. It's
Right.
not like usually it's the gray areas when you have employees that go beyond. And even if they do go beyond, if they have authorized, it's like
You could, yeah. So I've done this in many of us have done this in the roles that we hold as security professionals. I'm working for an organization. I always, and encourage our audience to do the same, to get permission from the organization to say, hey, I'm going to go test our stuff.
Written permission.
Buildings, computers, files, all that stuff. I want you to give me permission to say, like, if I test this and I gain access to something that you've granted me, that I'd have access to that.
Well,
Right?
it was just that case that came down when Doug and I were actually starting a paper on it, where the guy was breaking into the courthouse as part of the pen testing process.
Yes.
It's you just don't know, and in that case there was permission, but apparently the Chief Justice had no idea what was going on during
It was
the
a
whole process.
jurisdiction.
No.
Usually it's a pissing contest between who
exactly
should
what it was.
have
And
because
who should have the
the
permission?
sheriff
to grant
was
permission?
embarrassed. The sheriff was embarrassed, and he was going to show them that you're not going to make me look like an asshole, and that's pretty much what happened there. I think,
Right.
Yeah,
but that doesn't come out in the decision.
Yeah. Right.
I mean, it did. I sort of came out in the wash after the fact.
It
and the
did.
stories that came out. But,
Yeah.
Paul, I remember back in the day there was a company that I worked for, as doing pen testing and security and all that type of stuff. And I said, look, I'd like some written permission so that when I'm doing my job and in finding these things and getting access to things that I shouldn't have access to, that I'm not going to get that I have permission to do so.
And that paper gives you access to it. That's why I encourage
Right.
people to get that paper to
Right.
say, when I break into things within my own organization, that I'm authorized to do
Well,
so.
in that
even
case,
your
it didn't
own
help. They
organization.
had the paper. They showed it to the
Yeah,
to the
that-
sheriff,
yes.
and they still arrested him. It just
Yep. For my case, it was breaking into my own company, so it wasn't a third party. I was breaking into my own company, or the company that employed me. And their answer was, "It's a part of your job description." And I'm like, "That's not good enough." Like, I don't care if it's part of my job description.
Is it, Tom? You seem to think that it is.
Well, if they give you, if your job description says this is your job to do pen testing, security testing, and all this, then it's part of your job description. That's what you're hired to do.
Yep.
I'm hard pressed to believe that. It's not like you went out and parked cars and you cracked up a car and while you were doing it. I mean, this is what you were hired to do. And if that's your job description, then that's what you. Now, if you go beyond that, that's another story, obviously.
Right. And I think that's why we like to get the paper in case it could be interpreted that we went beyond the scope.
You always want it in writing.
Yeah.
Always get it in writing, no matter what. Even if it doesn't seem like it really has to be.
Yeah.
Get it in writing because.
You never know.
And they didn't want to give it. They didn't want to give me the extra in writing. Needless to say, I don't work there anymore.
And be sure you understand who has the authority to give you that in writing.
Oh yeah.
That's where
that's a whole issue in forensics of like who's the custodian of this really, because if somebody writes you a receipt and says, yeah, you can look at this, and they don't really have the authority to do that, you can have a lot of problems.
But that goes back to the coal fire case too. Very similar.
Yeah.
Who do I need to get permission from?
Right.
University.
Was it the court system? Was it
Yes.
who do I get? It's really a matter of, like Doug said, who's pulling the strings. I mean, there's cases where a town manager may hire somebody, and if that town manager is not authorized to hire you to do security testing because you needed approval of the city council, the town council, you've acted without authorization.
Right. Or
the
town hires me and the town has leased a building and I break into that building, but I didn't have permission from the actual owner.
Exactly.
That's typically where we get in trouble with
Yes.
this.
Lee's got a question or comment in here.
So where I work, we have, of course, classified data, but overall our data and all our accesses, there's the overall arching mantra that want to know is not need to know. That you're not authorized to get at that data unless you really have a defined need to know. And yes, it's defined who can give you that access or not. But I was questioning that what they're talking about. I've got access to a system and parts I don't have a need to know for. I shouldn't go poking around because I'm curious. I mean, it seems like a dichotomy.
Well, you wouldn't be running afoul of the CFAA. You wouldn't, because there was a case from 2000 called Sabinski. He was an IRS agent. And he was looking up files of his political enemies. He didn't do anything with them, but he had access. He had authority to look up IRS files. That's what he did for a living. That is the same situation because he may not have been, that's a purpose-related breach, but that's not a CFAA violation. So if you go into a system and you have carte blanche to go wherever you want, and you decide to go into an area that you shouldn't be in, that you think you shouldn't be in, but there's no restrictions, you haven't violated any law. I mean, it really comes down to how strong is that gate when it's down? How strong is that gate when it's down? If it's just, you can't go into this file. Okay, but I have access to it. But I don't want you to.
That's kind of interesting. If I have access to a file share, right? Maybe in Office 365. And I'm browsing around because I have access to it, and I happen to see a spreadsheet with everyone's salary information, and I look at it. What you're saying, Tom, that's not a CFAA violation.
Right.
No.
Oh, but I have a question. But first, I have to ask: is there a statute of limitations on these things established?
Yeah, I don't know what it is offhand, to be honest with you. There is a statute of limitations on virtually every.
Is it at least 30 years?
It's 18 months.
Okay, so when I was in college,
he's rolling his eyes.
I had a job at a state collection agency for people that were defaulting. Actually, I was trying to prevent them from default for student loans, and it was back in those days. It was I was on a mainframe terminal, and so all the data was in a database on the mainframe, and I could see everybody. And I had the ability, if I had wanted to, hypothetically, friends and family and colleagues just magically go in and check the little box, or I don't exactly remember what it was, but show that they were paid off. I could have done that. I had the access and the privilege to be able to do that. That was not my job function. crime or no
If you did
crime?
that would have been fraud.
I was going to say fraud.
Fraud.
I would have guessed correctly.
You would have guessed.
Yeah.
And here's the other thing about the CFAA. There's a lot of redundancy. I mean, wire fraud is computer fraud, but wire fraud carries a much stiffer penalty. It's
Yeah.
like 20 years, where this is 1 year 1 year for the misdemeanor. So most of these computer fraud prosecutions are under the wire fraud statute because
Right,
it's much.
'cause fraud is different. Von Buren wasn't committing fraud.
No, he wasn't.
Yeah.
Well, no, he wasn't committing fraud per se. But there are a lot of redundancies in the CFAA too, as well. So you wonder why they. And I always say, why didn't they just, if they wanted to prevent fraud, computer fraud, put it in the wire fraud statute? Well, but I think what happened was in 1986 they wanted to make a big splash that they were fighting computer abuse. So we're going to have this Computer Fraud and Abuse Act, and we're going to have a big signing of this bill, which really, for the most part, has been abused as a Computer Fraud and Abuse
Yeah.
Act.
It felt, well, very much in the beginning, too, because hackers were evil. They were teenagers living in their parents' basements, and they were wreaking havoc, and law enforcement at the time made a huge crackdown in the early 90s using the Computer Fraud and Abuse Act as the stick.
Because it was a mystery to most people. What computer knowledge and it's a mystery to me. Believe me, I am not a technical person, far from it. But I mean, if you ask anybody who worked in corporate America, which I did for 20 years, you don't mess with the computer folks. IT, you don't screw around with that, right? Because they can make your life living hell. And if you want
computer
something,
overlords.
they are. You just kind of just kiss up to them, and to a certain degree.
We would never.
No. I don't have access.
No.
Yes,
We'll get back to you in a year.
But sunspots could happen.
And do quite frequently.
Yeah, they do. Yeah.
Yeah.
It's like your whole account could be wiped out by magnetic interference from the sun.
It happens, I'm sure.
I mean,
certain
be a
planets.
shame something happened to it.
Yeah. So
Yeah, well, Tom, this was a lot of fun.
I'm glad.
Thank you for coming on the show.
I've never done this before. That's
You
what they
did
all
great.
say. So I'm glad I showed up. It was fun. It was
We need to
interesting.
ask you 5 more questions, though.
Oh, here we go. The same questions
what- I
I
was
was my
gonna say,
Yeah, so you've heard the questions because you got here a little early. So you've had time to prep.
Go ahead.
3 words to describe yourself.
Anal retentive. That's one word because it's hyphenated.
And he's a lawyer.
Right.
So, it's got to be one of them.
Somewhat funny. And
That's also hyphenated.
it's somewhat funny.
Hyphenated.
Yeah, hyphenated.
Fiduciary.
Fiduciary. I'm a fiduciary bag. That's what I am. Fiduciary bag.
Also
If you were a
hyphenated.
serial killer, what would be your weapon of choice?
Listening to Hall and Oates. That would make them listen to Hall and Oates over and over and over. Oh, they're not that bad, these are.
That is unique. Yeah.
That is very unique. If you wrote a book about yourself, what would the title be?
I hate change.
Just waste on your pants. I mean, can't we just go all with bills?
It depends.
No, I don't wear them.
Have you watched hacker movies? Like, do you have a favorite hacker movie? Like, do you
No, I
recall
don't really.
watching a movie?
I remember one with Matthew Broderick. Yeah,
Yeah.
with the
War Games.
War Games.
War Games. Yeah, that one there.
Ali
That's
Sheedy.
other- Yeah.
Favorite law movie?
Favorite law movie?
Well, I said Law and Order was your favorite.
Law and Order is my
can't
The
favorite.
TV show.
The
Yeah.
TV show is my favorite show.
Is that pretty accurate?
Yeah, it is. They have pretty good consultants on that
Yeah,
show.
yeah.
In fact, it pisses my wife off when I object and I rule on the objection, and my wife goes, "How did you know that? How'd you know they're going to?" Well, first of all, I saw the show 16 times. So it's not
Right,
like-
yeah. So you knew the outcome.
I knew what was
Yeah.
going to happen. And they always say the same thing. "All right, McCoy, I'm going to give you a little latitude, but just watch it. I don't want you to go too far with your questions." And you know,
Every damn time.
well, every damn time. And the only thing about the Law and Order that's not really realistic is it's like Perry Mason. They're like sticking their face right in the witness's face and cross-examining. No judge would allow that
Yeah,
to happen,
yeah, yeah.
especially, I mean, you're
That's
spitting
for
on them.
TV,
And,
right,
yeah,
right.
that's the drama part of it, yeah. So,
Choose 2
Still looking for
celebrities.
favorite. I want to hear favorite law movie though. I love
a law movie.
What's your favorite
a law movie.
I like The Paper Chase. It's an oldie but goodie. I always like
Yes. I wanted to ask you about that. Finish the 5
is-
questions,
oh my
and then I have a quick
Jeff
question.
is so excited. Choose 2 celebrities to be your parents.
Alive, dead, fictional, or
Alive, dead,
otherwise.
fictional, or otherwise.
Well, I already I was going to say Henry VIII. And actually, I would have been Anton Scalia would have been my father. And I don't know who my mother would be. I don't know.
If you say Henry VIII,
I was going to say
said it all.
Mother Teresa. I don't know.
I mean, Henry
but
VIII
she was
could
a
work. I
normal-
mean, welcome to 2021, right?
Yeah, really. Jeez, I wouldn't know who my mother was.
Jeff, did you want your off air code? Did you want
No, actually, because it was going to tie back to our first segment, because Paper Chase is actually one of my favorite law movies, and I was going to ask it figuring maybe Tom had heard of it, maybe Doug. I know Larry and Paul probably have never heard of
What
it.
now?
I haven't actually.
The Paper Chase.
It was a
Timothy
TV
Bottom
show,
was in it, right? Timothy Bottom was the
They made a TV
yeah.
show out of
Yeah,
it.
they
With,
did.
John
Yes, they
Gielgud
did.
and or no,
John
not
But-
John Gielgud. John
Hausman.
John
Yeah.
Hausman.
We stand by with the old guys talk. Yeah.
Marsh.
another Shakespearean. Yeah.
But the point I wanted to bring, my favorite part of that movie, which actually ties into the first segment on the whole, finding the right skill set and qualifications to be in this business. It's in this movie Paper Chase because, and I haven't seen it in many years, but there's, it's a story about it's colored, but it's a story about law students. I want to say first year law students,
Right.
but it doesn't matter. And one of the law students has a photographic memory, and so they think, I can ace this and become a lawyer because every legal book I read, I can recall. And the guy ends up, spoiler alert, failing miserably because he doesn't know how to apply what he's read.
Yeah.
Essentially, he can rattle it off, but he has no idea what it means.
Well, that's what I try
knew
to.
that, I knew that guy in real life. I really did. There was a guy in my PhD program like that. He could just like scan through stuff and he knew every bit of it, but he was completely failed to understand any of it. And
Well, that's
it was,
why I
like,
encourage
sad.
my students. I don't care whether they actually memorize the law. I mean, just tell me what the basic law is in your own words and how to apply it. It's the application, to your point, that they have a tough time trying to apply it because it's a critical thinking skill. And you got to practice. It's not something that happens to a lot of people just by doing it once or twice. It's something you do over and over and over. And after a while, you get the sense of this is the rule, these are the facts, does it or does not apply.
Right.
And you got to look at both sides of an equation. Law school was a miserable experience. I didn't go to law school to become a lawyer, by the way. I only practiced law for 3 years. I graduated law school when I was 39 years old. I had 2 small children. I was in banking for 20 years before that. I call it 20 odd years, and they were odd years. It was strange, the early 80s.
Well, thank you for bringing up the Paper Chase.
Yeah,
a great movie.
It's a good movie. I recommend.
yeah, it is. It is a very good movie. Mr. Hart. Yes, I remember that.
Mr. Hart. Yeah, interesting.
Tom, thank you so much for appearing on Paul's
Thank you,
Security
Paul.
Weekly.
I appreciate it. Thank you so much. It was
With
great.
that, we'll take a short break, come back, and talk about the security news. Stay tuned.